Has he shown any ill effects of spending time away from you or away from his mother that you're aware of?
Definitely away from me. Separation anxiety, that kind of stuff.
When the mother has had parenting time in the past, she has refused to return the child. You are the father of this minor child, is that correct?
Yes, sir.
Where do you currently reside?
I currently reside in Gaylord.
Yeah, is there a street address?
Yes, 1621 Jones Street.
And is that an apartment or a house?
House.
And is that a home that you own?
No, this is a home I rent.
Okay. And how long have you lived in that address?
Approximately 5 months.
Okay. And who else resides at that location with you?
My girlfriend, her son, and I see my other 2 daughters every other weekend.
Okay. And does your son Theodore live there the majority of the time?
Yes.
And what's the current parenting time schedule?
Every other weekend.
Okay. And have you allowed the mother of this child, pursuant to the court order, to exercise that parenting time?
Yes, sir.
And you apparently had some concerns about Mr. Hamlin, who resides in the house with her. Is that correct?
Yes, sir.
What were your concerns at the time of mediation?
Pretty much just his past and the few times that I've spoken to him in person.
Were you concerned about him being present during the time that that Miss Clark was exercising her parenting time?
Yes, sir.
And did you make that a requirement of a mediation agreement?
Yes, sir.
And was it your understanding, based not only on the mediation agreement, but Judge Hunter's order of July 11th, that he would physically not be present during that parenting time?
Yes, sir.
And do you have reason to believe that he has been?
Yes, sir.
Have you talked to Ms. Clark about that issue?
A couple times, yes.
And what has her response been? Has she admitted it?
A couple times, yes.
Okay. Do you know anything about Mr. Hamlin's criminal background?
Yes.
What do you believe it to be the case?
From what I've seen, it ranges from dangerous drugs to burglary and even domestic violence.
Okay. And is that the type of those things, if they were true, would cause you to be concerned about your young child being present?
Yes, sir.
Okay. Now, the parenting time that Ms. Clark agreed to, you didn't force her to agree to that agreement, did you?
No, sir.
You didn't threaten her in any way to agree to allow her parenting time only on weekends, every other weekend, did you?
No, sir.
Okay. And that current schedule, is that the schedule you're asking the court to keep in place?
Yes, sir.
Your young child has been going back and forth under this temporary order since actually before July, isn't that correct?
Yes.
Has he shown any ill effects of spending time away from you or away from his mother that you're aware of?
Definitely away from me. Separation anxiety, that kind of stuff. Same with his mother, though.
So, your son is now how old?
2.
And during his lifetime, have you been, do you have a strong emotional attachment to your child?
Yes, sir.
And do you love your child?
Yes.
And does he appear to share that feeling towards you?
Yes.
How does he demonstrate his emotional attachment to you?
For instance, when I come home from work, as soon as he sees me, he just wakes up and runs to me and gives me a hug, tells me he loves me.
And do you put him to sleep at night? You tuck him in?
Yes.
And when he wakes up in the middle of the night having a nightmare or any kind of distress, are you the one that goes to attend to him?
Yes.
Do you feed him as well?
Yes.
Now, you work during the day, do you not?
Yes.
And can you tell the court where you work?
I work for Reith Riley.
And is that a full-time job?
Seasonal full-time, yes.
Okay, and now we're coming up to, here we are in November. Is your employment with that company going to cause you to be laid off?
Yes,
Does that layoff, in fact, create more time for you to be with your child?
yes.
Currently, while working, who watches the child during the weeks he's with you?
Most of the time it's my mother.
And does he have a strong attachment to his grandmother?
Yes.
Now, again, he's only 2 years old. Are you involved in any kind of organized religion at all?
No, sir.
Okay. In terms of your ability to provide food and clothing and medical care for the child, does your employment afford you income sufficient to properly care for the child?
Yes, sir.
And since the entry of this order, has there been any child support paid by Ms. Clark to you to help support her son?
No, sir.
Do you have any reason, do you have any understanding as to why she feels she has no obligation to help support her child?
No, sir.
And again, are you the one that buys your son clothing?
Yes.
And again, you've already indicated your income allows to provide adequate housing for the child?
Yes, sir.
The child has lived with you continuously since when did you and Miss Clark go your separate ways?
Been
April.
April.
Okay, April of 2023.
Yes, sir.
So the child has lived pretty much exclusively with you since that time, isn't that correct?
Yes.
Do either you or your son suffer from any medical conditions? And as it relates to you, that would in any way impede your ability to parent your child?
No, sir.
Has your son been relatively healthy?
Yes.
Are you the one that would take him to doctor's appointments if and when it was needed?
Yes, sir.
Now, you understand this temporary order provides you joint legal custody with the child's mother. Do you understand that?
Yes, sir.
And you know that that requires you to be able to discuss major issues affecting your child?
Yes, sir.
Are you able to adequately communicate with the child's mother?
Yes, sir.
Now, she made some reference about you withholding the child prior to the entry of the court order. Was that true?
Yes.
Is there a rationale?
Because her boyfriend was there.
Are you aware of any domestic violence that has gone on within her household since the entry of the last order?
Yes, I have reason to believe so.
Okay. Does Ms. Clark have a bad temper that you've witnessed during your time together with her?
Yes, sir.
Has she ever committed domestic violence against you?
Yes, sir.
First of all, when would that have been?
That was probably a couple years ago.
Did she hit you?
Yes.
Did you call the police?
No, sir.
Do you have concerns about her emotional stability?
Not really sure about that.
Okay. But if Mr. Hamlin continues to reside in that house, do you believe that that would be an ongoing concern for you and your child?
Yes, sir.
Was there ever a time when you gave the mother parenting time when she refused to return the child?
Yes, sir.
One of the factors under the child parenting time statute in Michigan talks about the likelihood that the child would not be returned to the other parent. You believe that that's a concern if you went on this week on, week off basis that she's suggesting?
Yes, sir.
Okay. And again, are you simply asking the court to keep in place what she agreed to and what Judge has signed an order for?
Yes, sir.
Okay, thank you. Judge, I have nothing else.
Thank you. Ms. Clark, you have the right to ask questions of this witness. Do you have any questions you wish to ask?
No, sir.
All right, thank you. All right, Mr. Blumberg, any additional witnesses?
No, Your Honor, I don't. Let's switch seats.
All right, thank you. All right, so Ms. Clark, you do have the opportunity to make any closing statement or argument you would like to make. Is there any closing statement you wish to make?
As far as having a bad temper, I have went to a therapist. I started going to a therapist, and then during the time Caleb and I were still together, I had quit seeing the counselor and the therapist. But given recent events like that have involved, given the recent events of basically losing my child, because that's what it feels like, I have sought out to speak to the counselor again, and I have upcoming appointments. But I have spoken to my counselor about anger issues and how to resolve them. But that's all, sir.
All right, thank you. Mr. Blumberg, any closing statement?
Judge, I would just ask the court to respect what was clearly the wishes of the parties when they entered into that mediation agreement, which created a joint physical and joint legal custody arrangement. And the mother specifically agreed to a parenting time schedule that I would think she believed to be in the best interest of her son. That's been in place for a very long time now. The court has only heard testimony today, relevant testimony, about what the best interest of this child is, and the fact that when the mother has had parenting time in the past, she has refused to return the child. We believe that the court has kind of changed its view as to whether or not a change in circumstances needed to be established. I don't necessarily share that view. Obviously, you're the one that's going to make the decision. There just simply isn't any evidence to change what's been in place. And we're going to ask the court to simply continue the order of Judge Hunter.
Thank you. So in reviewing the matter, when looking at, again, the mediation agreement as well as the order that followed that, I do see that as a temporary custody agreement that contemplated potentially a hearing or some additional terms to be added. So I'm not requiring a showing of proper cause or a change of circumstances, as I don't find that was a previous judgment given the language regarding a temporary agreement. The court does still have to consider whether or not there's an established custodial environment with either parent or both. The testimony is that since at least April, dad has had the primary care, and that is consistent with the agreement that was reached in July. Given the young age of the child, the last 6 months is a significant portion of that child's life. So I do find that there is an established custodial environment just with the father at this time. Therefore, any change in the established custodial environment must be proven by clear and convincing evidence when examining the best interest factors. When looking at the best interest factors, the first factor being the love, affection, and emotional ties that exist between the parties involved and the child. There was not significant testimony from the plaintiff regarding this factor, but she did indicate the child's distress when she would leave the room. And when they're separated, dad certainly testified regarding his bond with the child. This factor doesn't contemplate who has the stronger bond, it just doesn't one exist. So based on the testimony, I would find this factor is equal. The next factor is the capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed. The plaintiff really did not provide any testimony as to how she provides those needs for the child. The dad did provide testimony on how he provides for the child, so I would find this factor favors the defendant father. The next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, and medical care. Dad testified regarding his employment and his ability to provide those needs. We did not hear testimony from the mother regarding this factor. Therefore, I find that this factor favors the father. The next factor is the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Dad has testified that he has been at his current rental for about 5 months, which would coincide with the time that he has been the primary caregiver for the child. Mom has testified that she has a stable residence. However, the concern is the individual that the parties had agreed to not be around the child does live there, and potentially has had some contact with the child, albeit potentially not a ton, but there is some acknowledged testimony that there has been times where he was at the residence despite the court order. So given those factors, I would find that this factor favors the father. The next factor is the permanence as a family unit of the existing or proposed custodial home or homes. Neither party testified that they have an immediate plan to move, so their current residence is considered, in the previous factor would be the residence here. Dad testified that he does have his mother in the area, helps out. And again, their concern is with mom's residence, is the individual that was prohibited from being around the child is in that residence. Given those issues, I would find this factor favors the defendant father. Next is the moral fitness of the parties involved. There's certainly some raising of some potential moral fitness issues, but given the testimony, I don't find that there's any support that either party has a moral fitness issues that prevents their ability to proper parent. So I would find that factor is equal. Next is the mental and physical health of the parties involved. Again, I don't find that there's any evidence that either party has a mental or physical health issue that impacts their ability to parent. So this factor is equal. Next is the home, school, and community record of the child. This child recently turned 2 over the summer. This child, given the child's age, I don't find that this factor is applicable. Next is the preference of the child. Again, given the child's age, and not that factor is applicable. Next factor is the willingness and ability of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. Both parents make some accusations that the other parent is impairing that relationship or is sought to impair that relationship. Dad withheld the child, but he also expressed the reason why was the individual that was around mom. And that actually became a stipulated order that that person would not be around. So his withholding for that concern should not be considered a negative impact on this factor. Dad has testified that there's been times where mom has not promptly returned the child. But given that there really hasn't been a showing of an aggressive attempt by either parent to sever that relationship, I'm going to find this factor is equal. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the child. And this can be considered throughout the parties' relationship. Dad testified that there has been domestic violence against him, and he was hit by the plaintiff previously. That there was no testimony to refute that or argue against that. So therefore, I find this factor favors the father. Clearly, when looking at the best interest factors as a whole, there is not clear and convincing evidence that the established custodial environment should be changed. Therefore, the court will recommend that the parties share joint legal custody, that dad have the primary physical custody, that mom continue to have the parenting time every other weekend from Friday at 6 until Sunday at 6 with exchanges at the Vanderbilt gas station. Those weekends should stay consistent with what they have been. So for example, this weekend, who has the child this week?
Is it your weekend or hers? It's my client's weekend, Your Honor.
All right, is that correct, Ms. Clark? You had the last weekend, so this weekend is Mr. Dantel's?
Yes.
Okay. So then Ms. Clark's next weekend would begin on November 10th. And it would continue to be every other weekend. I will also indicate the parties should share holidays pursuant to the Otsego County holiday schedule unless the parties agree otherwise. I would continue the provision that Kenneth Hamlin shall not be present during plaintiff's parenting time. There simply was not sufficient evidence offered to show that that provision should be removed. So that will stay. And your child support recommendation shall be prepared. Mr. Blumberg, well, I would also indicate that I'm going to give this matter immediate interim effect so that Mom's weekend would happen next weekend. Obviously, the parties still have the right to object, though, to the court's recommended order. Mr. Blumberg, do you have any questions?
No, Judge, I understand. Thank you.
All right, thank you. Ms. Clark, any questions, ma'am?
No, sir.
All right, thank you to the parties and counsel for appearing. That does conclude this matter.